Welcome back to Lawyer Stories, the podcast where we delve into the intricate real-world scenarios that land on the desks of legal professionals. I'm your host, Mark, and today we're discussing a truly unique situation that recently came across my desk from one of our long-standing clients, a law firm in Connecticut, seeking guidance on a rather unconventional property dispute. It highlights the importance of clear contracts, diligence, and understanding property rights, even when circumstances seem utterly bizarre. The case involves a homeowner, let's call him Mr. Evans, who reached out to our client after receiving a bill for a brand new driveway he never ordered. The situation began one afternoon when Mr. Evans returned home from work. He pulled into his driveway, or rather what was now his driveway, to find it freshly paved. This wasn't a minor patch-up or a seal coating job, it was a complete repaving, including the removal of the old surface and the laying of new asphalt. His immediate thought, naturally, was confusion, quickly followed by a sense of unease. It soon became apparent what had happened. His next-door neighbour had indeed contracted a paving company for their own driveway. However, due to what can only be described as a significant oversight, the paving crew showed up at Mr. Evans' address instead. They proceeded to complete the entire job, from demolition to final laydown, while Mr. Evans was at work, completely unaware. The neighbour, upon realising the error, was, to put it mildly, super pissed at the mix-up, and the paving crew subsequently returned to complete the correct job at the neighbour's property a few days later. For Mr. Evans, the initial reaction was a mix of disbelief and a quiet hope that perhaps, through some strange twist of fate, he had simply received a fortuitous upgrade. No one from the paving company approached him, no apologies were made, and so for about a week he casually ignored it, thinking he had perhaps, truly, gotten a free driveway. That illusion, however, was shattered when a formal bill from the paving company arrived in his mailbox demanding payment for the work. This, understandably, sparked considerable anxiety. Mr. Evans had never solicited their services, never signed a contract, and had no prior contact with this company whatsoever. His primary concern was whether he was legally obligated to pay for work he never authorized, and whether engaging with the company would simply open him up to further demands or exploitation. He also had the foresight to consider potential town permit issues for unpermitted work. From a legal standpoint, this case presents a fascinating interplay of contract law, property rights, and equitable principles. Our initial assessment for our client was clear. Absent a valid contract, Mr. Evans has no direct contractual obligation to pay for the services rendered. Connecticut law, specifically the Home Improvement Act, requires that a contractor cannot force a homeowner to pay for work unless there is a written contract that meets several statutory requirements, including both parties' signatures, notice of cancellation rights, and defined start and end dates. None of these elements were present here. The paving company simply performed work on the wrong property. The paving company's actions constituted an unauthorized entry and alteration of private property, which legally amounts to trespass and, arguably, property damage or conversion, depending on how one views the removal of the original driveway. They had no permission, express or implied, to be on Mr. Evans' land, let alone to undertake a significant construction project. However, the situation isn't entirely without nuance. The main legal avenue the paving company might attempt to pursue is a claim for unjust enrichment or quantum merit. This is an equitable remedy based on the principle that no one should be unjustly enriched at the expense of another. To succeed, the company would typically need to prove three elements. First, that a benefit was conferred on Mr. Evans, a new driveway. Second, that Mr. Evans unjustly failed to pay for this benefit. And third, that the company suffered a detriment. This is where the details of Mr. Evans' situation become critical. A key defense against unjust enrichment is the absence of knowledge or an opportunity to reject the benefit. Mr. Evans was not home when the work was done. He had no prior indication, no quote, no consultation, no opportunity to intervene or object. He simply returned home to a completed, unauthorized project. This factual detail is paramount. Had he been home, observed the work in progress, and remained silent, knowing it was a mistake, an argument for unjust enrichment might hold more weight. But in this scenario, his lack of knowledge removes a fundamental requirement for such a claim. Despite the strong legal position, there are practical risks Mr. Evans faces if he simply ignores the bill. The company, determined to recover its losses, could resort to sending the bill to collections, negatively impacting his credit, or even attempting to place a mechanic's lien on his property. While such a lien would likely be fraudulent and ultimately dismissed due to the absence of a contract, it would still create a significant headache and expense for Mr. Evans to have it removed, particularly if he were looking to sell or refinance his home. There's also the unlikely, but not impossible, scenario of the company, out of spite or frustration, attempting to return to repossess their work by ripping out the new driveway. However, doing so would only compound their legal issues, as they would be destroying Mr. Evans' property. The newly installed driveway is now legally his, and would be obligated to restore his property to its original asterisk condition, an incredibly costly and logistically challenging endeavor. Given these considerations, our advice to the client was to adopt a calm, confident, and proactive stance, but to do so strategically. The first step for Mr. Evans was to thoroughly document everything. This included taking detailed photos of the new driveway, gathering any existing photos of his old driveway. Even old Zillow listings or Google Street View images could serve as valuable evidence of its prior state, and meticulously retaining the unsolicited bill he received. Installing security cameras covering his driveway was also a prudent measure to deter any potential future unauthorized entries or attempts at destruction. The next critical step, we advised, was to have a formal communication sent to the paving company, but not directly from Mr. Evans initially. A letter drafted and sent by our client's law firm would carry significant weight. This letter would clearly state that Mr. Evans never authorized the work, had no contract, and therefore no legal obligation to pay. It would explicitly reference the Connecticut Home Improvement Act and the requirements for a valid contract, highlighting the company's failure to adhere to these. The letter would also formally prohibit the paving company, its employees or agents from any future entry onto Mr. Evans' property, serving as a clear trespass notice. It would demand that the company cease all collection attempts and refrain from any actions to place a lien on the property, warning of counter-litigation for trespass, damages, and fraudulent lien filing if they persisted. Furthermore, we addressed Mr. Evans' concern about town permits. Since the work was unauthorized, it's highly probable no permits were pulled. We advised him to discreetly inquire with his local town's building department to understand the requirements for such work. If permits were indeed required and absent, this creates an additional leverage point, as the company could face fines and be compelled to rectify the situation, making it even more financially disadvantageous for them to pursue Mr. Evans. While some might suggest a friendly offer to pay for materials to make it go away, we generally advise against this unless absolutely necessary to avoid a protracted dispute. Offering payment, even a nominal amount, could inadvertently be construed as an admission of some liability, which Mr. Evans clearly does not have. The company's goal is to mitigate its loss, and Mr. Evans holds the stronger legal position. The most likely outcome, if faced with a firm and legally sound refusal from a law firm, is that the paving company will write off the loss as an expensive mistake and move on. In conclusion, Mr. Evans' case underscores the robust protections afforded to property owners against unsolicited services. While the situation was undeniably stressful and confusing, a clear understanding of the law and a strategic, well-documented response provides a strong shield against unwarranted demands. It's a powerful reminder that even in the most unusual circumstances, clear legal principles often prevail, and knowing your rights, along with professional guidance, is invaluable. That's all for this episode of Lawyer Stories. Join us next time for another deep dive into the fascinating world of law. I'm Mark, and thank you for listening.